Constitutional Court ruling yesterday said that there was no conceivable purpose nor rational connection as to why a South African should automatically lose their citizenship when they acquire the citizenship of another country. The court also noted that the vast majority of countries around the world now allow their citizens to also be the citizens of another country. Stefanie de Saude Darbandi is an immigration and citizenship law specialist at De Saude Darbandi Attorneys. Stefanie, good morning to you. I really do appreciate the time. Thank you very much indeed for joining us this morning. How important is this ruling? It seems to basically allow South Africans to be dual citizens of other countries and no one can stop them. Is that the right interpretation of this judgment?
To a certain extent. So it's very important. It's an affirmation of constitutional rights. It goes beyond the right to allow people to obtain foreign citizenship without having to first acquire the minister's consent. I think we need to unpack that. I think this ruling confirms that the minister doesn't have this broad, unchecked power to strip people of citizenship, which is a constitutional and fundamental right, as confirmed by the court. And it also reaffirms to the people of South Africa, and this is why I think it benefits the whole of South Africa, even those that might not be interested in acquiring a second citizenship, that our courts are there to protect and that South Africa does respect constitutional rights, human rights, and values and respects individual rights.
You touched on something that's very important here. Under the law as it was before yesterday's ruling, the Home Affairs Minister had the power to decide alone. So the Home Affairs Minister on their own could decide whether somebody should be allowed to remain South African if they were also the citizen of another country. And there was no criteria, no guidance, no rules. They could just decide. You get to do it, you don't. How important was that to this case?
So it is important because the minister's rights his rights are limited, and it's limited under the Act and it's limited under the Constitutional. And that automatic loss provision, as I mentioned, gave him this, as I say, this broad, unchecked power to simply strip people without fair process, without notice, and without due process, and without any consideration of constitutional rights. As the court pointed out, stripping someone of their right of citizenship is one of the most serious things a state can do. And I just want to say one other thing. This case doesn't open the floodgates to allowing people to obtain citizenship. It simply closes the door to arbitrary deprivation of citizenship. So it cancels an unlawful penalty when one acquires a foreign citizenship.
So could there still be penalties that are lawful? Could the Act now be changed? Could Parliament decide to pass an Act that would say, if you become the citizen of this country, any particular country, whatever, you cannot also be a citizen of South Africa, or there are certain criteria to decide whether you should, and remove some of that power from the minister, but still provide a legal framework that would mean you would not always retain your South African citizenship if you also became the citizen of another country?
So for one, I think that there's a lot of work that can be done with our current Citizenship Act. And by that, I mean to improve the Act. But it does allow for a legal framework for remember, the minister still does have powers. And people who acquire foreign citizenship are still subject to certain rules. So it's not this free for all, go and do whatever you want. The current Act in its current form does still provide for limitations on acquiring foreign citizenship. It also does still allow the minister to deprive a person of citizenship status, but it's under certain circumstances. And the most important thing that the court stressed is that it must be done by due process and following constitutional principles. It cannot simply be unilaterally stripped without any notice.
As I understand it, what many people have been doing, if they are a South African and hold the citizenship of another country, and they were flying from South Africa to that other country, let's just pick an example, say they were also Nigerian citizens. They would leave South Africa on their South African passport. They would enter Nigeria on their Nigerian passport. But if they were to try and enter South Africa on their Nigerian passport, there could be problems. Is that still the case?
Yes, so that was implemented in 1997. It's a criminal offense for an adult South African, not a minor, only an adult South African, to exit and enter South Africa on a foreign passport. So again, South Africa allows dual and multiple nationalities, but if you're an adult South African, you have to exit and enter South Africa on a South African passport. My apologies.
What happens if you don't? Could you lose your South African citizenship then?
No. So again, it's a criminal offense. The penalty is a fine or imprisonment. And of course, because we have the right to constitutional right to freedom, if there's a lesser offense, generally they would go with the lesser offense, which is a fine. And in my 20 years of being in this field, practicing exclusively, I've very rarely heard of anybody being fined. They're usually warned. They're usually being given a bit of a, difficult time. This case clears a lot of confusion, not only for South Africans, but border management control as well, because you'll have a lot of South Africans who lost their status in terms of this the automatic loss provision, and entered South Africa on a foreign passport, and border management somehow, I don't know, maybe through discussing with these people, because really the only way Home Affairs would know if you acquired a foreign nationality is if you told them, but then they would give them a difficult time saying you're committing an offense, you should be entering on a South African passport, when they're saying, but hold on, I'm not allowed to because I've lost it. So it provides a lot of clarity in that respect as well.
There are some people who have claims on 3 nationalities. And the word that we've been using for much of this conversation, and certainly the word I've had in my mind, has been the word dual. In other words, you would have 2 citizenships. It is entirely possible that there are plenty of people who would have claimed to 3 or 4. Think of Barack Obama, for example. Kenyan father, American mother, spent part of his time at school in Indonesia. Under our law, does it matter how many you have after yesterday? Not at all.
Not at all. And before yesterday, it also didn't matter. Let me also just say that. So before yesterday, you could be a South African citizen by birth, you could be a Portuguese citizen by descent, and you could be a Spanish citizen by marriage. And then you could be naturalized an American citizen, but you needed to get the minister's prior written consent. So that was the difference before yesterday. The difference now since yesterday is simply that you can now become naturalized an American without first getting the minister's prior consent.
So, as I understand the ruling, people who had their citizenship removed or revoked, I think the word is deprived, or there'll be another legal word for it, can now have it restored. Do we know how many people this will affect?
So I think it was hundreds of thousands, to be honest with you. And what the ruling is, it's not that it can be reinstated, it's that it is reinstated. So if you cease to be a South African in terms of that automatic loss provision, your status is now reinstated. A lot of those people will need to have their statuses updated on the Home Affairs profile because they've either lost it and became, so if you were naturalized a South African, you lost your status completely, but if you were born South African, you were then deemed a permanent resident, and your ID number would have changed to reflect that. Those people will need to have their status updated on the system. Those that didn't disclose to Home Affairs or Home Affairs didn't make any changes on the system would not need to do anything. But yes, so there is practical steps that will need to be taken for a number of those people as well.
I mean, I presume they can't now go to a high commission or an embassy in Nigeria or London or wherever and demand their citizenship documents today. It'll take some time.
It will take time, especially at a foreign mission. So foreign missions generally will want to do a determination of status. I would imagine that would now, I don't think Home Affairs would completely do away with it. They should do away with it in most of the cases, because one of the reasons for doing that was to understand if they lost their status in terms of that automatic loss provision. But then again, you may have some people that formally renounced their status. So they may want to check that. But yes, it's still going to be a process, even if the systems are updated. We have no idea. I think we have to wait for further directions from the minister to see how what steps these people are going to take. And then, of course, you have a few, and I think there are a few, South Africans that don't want to reinstate their status. So we'll need to know what happens to them. Do they need to formally renounce, or no, they just continue as they have with their foreign status? That's going to make it difficult, of course, if they want to travel to South Africa, because of that rule that says you have to enter with a South African passport.
Stefanie de Saude Darbandi, thanks very much indeed.